everybody? What's going on, everybody? I want to talk about courts and jurisdiction and why you should never panic because the court kind of railroaded you in a court case, or they want to move past you, on a court case. And let me explain the number one key before you even go forward in court is to understand that you need to study your constitution. I cannot express this. I can't express this any how important it is to know your constitution. Okay, so if you understand your constitution and you know how to look up certain landmark cases or certain cases, it will definitely help you in regards to challenging jurisdiction and things of that nature. So we will get to that. Okay. So it says circuit courts are constitutional courts with plenary jurisdiction. So you have to look up what plenary power means. They do not depend solely upon the statute for their powers. Okay. This is why I try to tell you do not go into challenging certain elements, even though all of their statutes, all of their stuff, a lot of their stuff is missing bodies and active clauses. They're void for vagueness. These are some things that you may not know. Okay, however, in certain cases with vast social ramifications not addressed by the statute, prudence requires the courts to refuse to exercise their jurisdictions. So when people ask you, how come you can't prove this in court? How come you don't have any evidence of this? You can't prove everything in court because the court can use its own discretion. Okay, so when people say, "Oh, I've never seen a case dismissed for accepted for value. I've never seen a case dismissed because somebody brought a bond and discharged it," because they don't have to show you it. Okay, they have a right to basically run their ship as they see it fit, as long as it doesn't affect the Constitution or the rules of civil procedure. Okay, as such, circuit courts are prohibited from exercising jurisdiction in regards to sterilization of incompetence. Okay, that doesn't mean much. Okay, because courts have exclusive criminal jurisdiction, criminal charges against the defendant were not collaterally estoppel. Now, let's go understand what a collateral estoppel is. Because this is why I always tell you to accept the charges. Doesn't mean there's so many ways to beat a court case. There's not just one. So if somebody tells you, "Oh, this is going to be perfect," well, it's not always perfect. You have to understand you're always dealing with human beings. And as I say, humans are going human. So just because you follow the law doesn't mean they're going to follow the law. But you need to know what to do when they don't follow the law. Okay? So collateral estoppel. Okay. Collateral estoppel is important doctrine in the fields of criminal law and civil procedure. In criminal law, collateral estoppel protects criminal defendants from being tried for the same issue more than one criminal trial through the double jeopardy clause of the Fifth Amendment. As established in Benton versus Maryland, collateral estoppel is binding on both federal and state governments through incorporation by way of the due process clause of the 14th Amendment. So you hear stuff on the internet like, "Oh, you're a 14th Amendment citizen." People don't understand even 14th Amendment citizens have rights. Okay. You're a US citizen. Even US citizens have rights. Okay. You still have a right to due process regardless of how you are in court. But when you go into court and you start engaging and you start not following the rules of court, this is how they obtain jurisdiction over you. You can stop any court from having jurisdiction when you act fast. It's just like a mortgage. It's just like everything else. It's easier to discharge it when you're current and you're acting fast. In civil procedure, collateral estoppel refers to the application of res judicata principles through issue preclusion. For issue preclusion, a party can utilize collateral estoppel to prevent another party from relitigating any issue that has been validly finally and actually determined on the merits in a previous case. In deciding if, I mean, technically, if you were, this would work if somebody was trying to bring your old cases into a soul, like a DUI, or to bring up your old criminal record and such. I mean, if you know how to object to that, there's certain ways to do that. Okay, in deciding if given issues have already been determined, the court will consider whether the issue was essential to the previous holding. Under this test, any issue previously raised in court would change the outcome of the case had it been decided differently. It is deemed actually determined. Okay. The validity and the finality for the purposes of collateral estoppel are determined whether the first case will survive collateral attack. Now, we're going to move to collateral attack. This is why I always tell people to the accept the case or accept it. You have to act fast because when you're going to the court, they're trying to establish a jurisdiction over you. Okay, that's why I'll get to it though. So a collateral attack. Okay, a collateral attack is also called an indirect attack. Is a challenge on the validity of a prior judgment through a new case rather than a direct appeal. So people don't know that you can actually bring up an issue and say you were done dirty at court. You don't have to go and appeal. You don't have to wait that time frame for appeal. You can actually go and you can actually bring up a collateral attack. Okay. Examples include habeas corpus petitions and claims that prior judgments were invalid. See, prior judgments were invalid after the opposing party cites it for strategic advantage in a new case. See, you didn't know that. So if you have a criminal record or you have certain things that they try to bring up in your case, you can collaterally attack it. Okay. Under the principles of res judicata, an issue/claim has already been litigated on its merits is a bar on future lawsuits. The party is collaterally estoppel from raising it again. As a result, a party wishing to relitigate an issue/claim which has already been decided on, the merits must show that the initial judgment was invalid by way of collateral attack. So they already telling you how to get rid of old traffic tickets, old court cases, everything. Common grounds for collateral attack include lack of personal jurisdiction. In most traffic cases, the court lacks personal jurisdiction. So people have this presumption that a court has personal jurisdiction. Remember, the traffic ticket does not give the court personal jurisdiction. The fact that you've never challenged it does, because it's used as prima facie evidence. This is why I try to teach people to look up prima facie evidence and to understand it. Okay, the courts don't get jurisdiction by minimum contacts. They get jurisdiction by prima facie evidence. So, as we discussed on the law call, prima facie evidence is Latin for at first sight. Prima facie may be used as an adjective meaning sufficient to establish a fact or to raise a presumption unless disproved or rebutted. An example of this would be to use the term prima facie evidence. Okay, first of all, prima facie evidence is BS. Okay, it's just a way for the court to hear a case. So when you're challenging jurisdiction, you have to do it intelligently. You can't just say, I challenge subject matter jurisdiction. The court's going to say, well, we have subject matter jurisdiction. And you have to say, well, under this ground, you don't have subject matter jurisdiction. You have to, if you react late, you have to kind of basically back it up and stop the court from having subject matter jurisdiction. Okay. Or personal jurisdiction or etc. But you have to intelligently argue this. You can't just say, y'all don't have personal jurisdiction. Y'all don't have subject matter. You have to intelligently argue it. It may be used as an adverb meaning on first appearance, but subject to further evidence or information. Okay, if somebody is alleging something and they haven't attached evidence to the complaint, you can object to that. Okay, they have to have a ruling on the merits. If it's not ruled on the merits, you can come back and attack that at any time. An example of this would be to use the term prima facie valid. A prima facie case is the establishment of a legal requirement rebuttable presumption. Okay. A prima facie case is a cause of action or a defense that is sufficiently established by a party's evidence to justify a verdict in his or her favor, provided such evidence is not rebutted by the other party. Well, this is a very simple thing. If you understand the rules of civil procedure, he when you read stuff like creditors in their bonds, as I've explained to people in numerous occasions, creditors in their bonds is a nice for people who are just getting into this, but it doesn't really mean anything. Okay. Now, what is the bond? The bond is the evidence of indebtedness. I've already showed you this. So when people are on my videos and they're saying, stuff in the comment section, I appreciate comments, but sometimes you have to understand, you got to step back and listen to what I'm saying. Because instead of regurgitating things you heard, you have to have knowledge behind it. The reason why the court is perceiving or proceeding in a case is because there is some sort of agreement between you and them, which constitutes as a bond. A bond is there to bind someone to a specific performance. Okay. So a complaint can be used as a bond. Why? Because it allows the court to engage with you and request that you appear. That's the bond. They don't always have to have a surety agreement. Okay, application. Various torts will typically have prima facie cases attached to them. A plaintiff would typically need to prove that a defendant has met all the components of prima facie tort case in order to prove that the defendant has committed that tort. For example, the tort of trespass has a prima facie case with three components. Okay, the defendant had the intent to invade the land. The defendant invaded the land. The plaintiff possessed the land and did not consent to the defendant's evasion. If the plaintiff is not able to prove one of the components, the court will likely find that the tort did not occur. Now, we're going back to courts and why most people lose in court. Okay. While circuit courts possess plenary jurisdiction, not dependent on legislative authority, authorization. Okay. So they have plenary powers within their case because really what they're doing is running a debt collection. So that's why when you get a court case, what they'll do is they'll extend the court. Like when you get a traffic ticket, after you get it, it's usually they have a court case set within 30 days. Well, the reason why they do that is because you're defaulted. They're trying to default you. So they're giving you 30 days to deal with the matter before it goes in the hands of the court. It's all of this is just a debt collection. It doesn't matter how serious the case is. It's a debt collection. So under some circumstances, they may lack competency to act. So if people remember, I brought up competency on the wall call, and I explained competency. Okay. Challenges to a circuit court's competency are waived if not raised in the circuit court, subject to the reviewing court's inherent authority to overlook a waiver in appropriate cases or engage in discretionary review of the waived competency challenge pursuant to certain statutes. Okay. These are the statutes of my state. Okay. Lack of competency is not jurisdictional and does not result in a void judgment. Accordingly, it is not true that a motion for relief from judgment on the grounds of lack of circuit court competency may be made at any time. Okay. So let's see. So it is not true that a motion for relief from judgment on grounds of lack of circuit court may be made at any time. Okay, so that's with this case. All right. So a circuit court may lack competency to render a valid order or judgment when the parties are seeking judicial review fail to meet certain statutory requirements. Okay, this is why I always tell you, you need to know your statutes. Not only failure to comply with statutory requirements will deprive the court of competency. Okay, remember, competency is different than jurisdiction. However, only when the failure to abide by the statutory mandate is central to the statutory scheme of which it is part of, will the circuit court's competency proceed to be implicated. So, a circuit court lacks competency but retains subject matter jurisdiction when the court enters a civil forfeiture judgment against under a municipal ordinance for a first offense operating while intoxicated. Okay, when you start reading these cases will show you what to bring up, how you find loopholes in the court's competency and jurisdiction. But this is not it. You know what I'm saying? You don't have to get into these legal arguments. So yeah, so it lacks competency. So you can challenge the competency of a court. Now, once you challenge the competency of a court, you can deconstruct the case. Okay. So the reason why I'm doing this is I want a lot of y'all to understand that the key to a lot of your problems is reading. Just read. Stop listening to everybody on the internet. Actually go read your until you have a understanding of law, until you have an understanding of your constitution, how your courts are structured, who can do what, who can't do what. That's what, you're able to do more things, different things in court. But if you don't have any understanding about jurisdiction and you go into court and you listen to somebody and they tell you to challenge the court's jurisdiction, you want to do it intelligently. Because if you intelligently challenge the court's jurisdiction, I mean, there ain't nothing else they can do. So if I challenge the jurisdiction of the court and then they proceed to abridge my rights, they have no protection. And I'll show you that. So a judge having jurisdiction of the person and the subject matter involved in acting within that jurisdiction and in his or her judicial capacity is exempt from civil liability. They didn't say criminal. You see what I'm saying? So once you learn that a judge can still be sued criminally. Yeah. So in this case, this is talking about civil liability. So if you're getting in a court, yes, you can object to the court having personal or subject matter jurisdiction. For me, I would just settle it and then I can bring these issues up because then I have proof, I have a record within the court that I can use against these people for failing to settle a matter. Now it becomes to a matter where they're abridging your rights. I'm out.